In a move that's stirred constitutional debate and heightened political tension in Benue State, the relocation of the local government election petition tribunals from Makurdi to Abuja has become the latest flashpoint in Nigeria's evolving democratic landscape. The directive issued by the state's chief judge has raised urgent questions about jurisdictional propriety, the accessibility of justice, and the constitutional autonomy of subnational judicial processes. The relocation has drawn particular concern from within the All Progressives Congress, where a faction perceives the decision as a disruption to due process and a potential compromise of electoral justice. At the center of this unfolding dispute is the role of the National Judicial Council, which now faces growing pressure to assert oversight and reinforce judicial standards. Joining us for an analysis is Daniel Onje, the APC chieftain in Benue State, and he brings both a political and constitutional perspective on what this moment means for the rule of law and the future of electoral adjudication in Nigeria. Good afternoon. Many thanks for joining us.
Thank you so much for having me here today.
Of course. Now, what specific judicial reforms would prevent this kind of crisis that we're witnessing in Benue State?
Well, it isn't about judicial reform, but about adhering strictly to the provisions of the Constitution. The Chief Judge of Benue State lacks the power to move a local government election petition tribunal to Abuja. His jurisdiction, his territorial jurisdiction and legal jurisdiction starts and ends in Benue State. And the other time, a judge of the High Court, FCT High Court, also made a pronouncement on an issue that borders on the local government election petition tribunal in Benue State, which is an aberration of the law. He ought not to, because his own jurisdiction or territorial jurisdiction also ends here, particularly when it borders on local government matters that are within the legal framework and legal and constitutional framework of the states. It is a state that has the power, as enshrined in the Constitution in Section 7 of the 1999 Constitution as amended, to legislate and also direct the affairs of local government. So very clearly, the Chief Justice of the Federation lacks the power to do that. This has well been overtaken by events because the tribunal commenced sitting, and the judgments so far that have been delivered by some of the justices shows clearly that indeed the judiciary is the last hope of the common man and the binding force of the society. They've been able to hold that the petitioners ought to have paid the security deposit, which the Chief Judge of the Benue State granted waiver in a very biased manner to the petitions. And immediately after granting the waivers, over 200 petitioners from the same party, APC, filed petition. And the second reason why some of the petitions have so far been dismissed is that the issues they are raising are purely pre-election matters. Because, one, they did not participate in the election. The electoral body, which is the electoral umpire, which is the electoral body in Benue State, the BSEC, did not publish their names as candidates. And tribunals don't entertain pre-election matters, particularly where the APC members who went to approach the tribunal were asking for declaration against the candidates of their party that already have been declared and performing their, sworn in and performing their functions. Tribunal is not there to settle who is a rightful candidate of a party in an election. But tribunal is there to settle dispute amongst candidates who participated in an election. So the members of the tribunals have given the judges at the tribunal, Benue State local government petition, election petition that have delivered ruling and judgment so far have acted in accordance with the law. So we hope that will be carried onto the appeal stage. As it is right now, some of the justices in Benue State are recusing themselves from the appeal panel already. I'm sure it is because of the vested interests that have been exhibited by some of the politicians in Benue State. Of course, they wouldn't want their reputations to be soiled or their names to be dragged to the mud. Obviously, that is what the situation is. But NJC can play a major role here.
All right, before we talk about the role of NJC, Mr. Onje, we're going to talk about the role of NJC, but I'd like to bring to the fore, especially the issue of the tribunal. We know that the role of the tribunal is to adjudicate on local matters. And in a case where it is now moved to Abuja, how does this impact the people, the community, whose cases are being brought? Who are the interested parties in the cases that are brought to the court?
Well, this is the point I was going to get to. The reason I believe the NJC was established is to play or have a supervisory role over the judicial activities in the country and also the major stakeholders in the judicial arm of government, which of course are the judges, and then also the justice. So now, the NJC has a role to play to end the protracted conflicts between the government, stakeholders, and the judiciary in Benue State. And this is how. The Constitution empowers the State House of Assembly to recommend the suspension of a chief judge of a state and also for the governor to suspend or remove a chief judge of a state. All these things, I believe, have been overtaken by events because for some political expedience and abundance of caution, the governor had come out to say, well, I am passing the recommendation of the State House of Assembly to the National Judicial Council. For me, that is that was done, that is superfluous. It was done in excess of what is required from him. The governor ought to have just made pronouncement and suspended the chief judge of the Benue State that have shown open bias for the petitioners. But he was cautious enough, and also, like I say, for abundance of caution, to push it over to the NJC. The NJC ought to have constituted a committee to look into the barrage of allegations against the chief judge of the state. But up to this point that I'm speaking with you, nothing has been done. The State House of Assembly has recommended the suspension of the Chief Judge of Benue State, Justice Bambese. Nothing has been done about that. The state government, through the Attorney General, had written petition to the NJC. Nothing still has been done about that. That leads us clearly to the pointer that there are vested interests in the crisis that is bedeviling Benue. And people are beginning to lose confidence in the judiciary. Not even beginning. People have lost total confidence in the judiciary in Benue State. How can a chief judge of the state that is an appointee of the governor, he is not an appointee of the NJC. So the Constitution couldn't have been wrong about his position. Where the Constitution stated the procedures in which a chief judge can be removed, it made it expressly clear in the provision of the Constitution where a chief judge can be removed at the recommendation of the State House of Assembly and by the governor. But the NJC haven't come out to say that that responsibility lies solely in it, which is against the express provision of the Constitution. Okay, good and fine.
All right.
The ball had been thrown into your court. And up to now, the NJC have not made pronouncement, have not considered a committee to investigate Justice Bambasi because of the vested interest that we've always been crying about. Some of the politicians from Benue State that we refer particularly to the Abuja politicians.
All right, Mr. Daniel
constituted themselves constituted themselves as clog in the wheels of justice in Benue State.
Mr. Daniel Onje, it's clear you're very passionate about this situation and we hope for a favorable outcome. But for now, we'd like to thank you for your time here on Newsday. Daniel Onje is an APC chieftain from Benue State. Many thanks for joining us.